I thank you for joining us today as we discuss 4 different ways that property can transfer after someone dies. My name is Elijah Keys, and I'm a certified specialist estate planner in California and the operator of Keys Law Group, an estate planning, special needs, and administration firm in Milpitas, California. There are 4 ways that property can transfer after death. The first way is if it's jointly owned. So you use a car with another person. It could be Joe and Maria who own the Toyota Prius. So if John passes away, then Maria has to provide a copy of the death certificate to the Department of Motor Vehicles along with several other documents, and John's name is removed from the car. Joint ownership is a bet. 2 or more people get together and co-own a piece of property, either a car, a bank account, a brokerage account, maybe even a property. And the joint tenancy, each person owns an equal portion of that. Each person is entitled to use it. And when one person passes away, the remaining owners have to prove that that person is dead. And when they do, then they are the sole title owners. It is not advised to use joint ownership as a substitute to an estate plan, such as a revocable trust or a will, because there are severe tax and ownership consequences to putting someone on as a co-owner of your assets. So please don't do that as a substitute. Second way the property transfers after death is through what's called a designated beneficiary. So a beneficiary is someone who is named in a contract like a contract to hold a retirement plan, or a contract to hold life insurance, contract to hold a bank account. If there's a contract and there's a beneficiary named, and the beneficiary designation is valid, there are plenty of times when the designation is not valid. If the designation is valid, then when the owner of that account passes away, or the account triggers, such as in life insurance, when the insured passes away, then the beneficiary is able to claim the account as his or her own. A claiming process is done by providing a copy of the death certificate to the bank or financial institution, and the organization then provides a beneficiary packet to the person who is entitled to the money. The beneficiary then fills it out and claims the money. The problem with using a beneficiary designation as a substitute for an estate plan is that the designations sometimes are lost, misplaced, incorrect, or in the worst case, they're done correctly, but the beneficiary doesn't know that they are an owner. That happens a lot of times in insurance policies, where life insurance companies love to collect your money and not pay it out to the beneficiary. And unless the beneficiary knows exactly whom to contact, exactly what to say, the life insurance company is simply not required to contact them until they are notified that you've died. And who else knows that you have a policy except you when you buy it? So it's really, really important to write down all the details of your accounts, write down the details of your policies, write down the details of who are the beneficiaries, and store it in a very safe place with a safe person. We hold those type of details for our clients quite often. And when someone passes away, we are notified by the families, and now we can help the families take action. Next way of transferring property after death is through a probate, and there are 2 varieties of probates. A probate is a court action to transfer assets after someone dies. The probate limit in California is $184,500 of personal property, like a bank account or stocks, or about $50,000 of real estate. If you have more than that, then you need a probate. Proceedings are long, complicated, difficult. I don't recommend that you go through it if you can avoid it. The 4th way of transferring property is a limited probate only done between spouses. One spouse owns assets in his or her own name, and they are owed to the other spouse. This is either done through a will has designated the other spouse as the owner, or because there was no will and the assets pass by intestate. Intestate means that there was no will, and so we go by the default rules of the state in which you live. And California allows for a limited procedure, not all states do, but California allows for a limited procedure for assets passing between spouses called a spousal property petition. Now, some people might say, Elijah, you didn't talk about a revocable living trust. Actually, I did. A revocable living trust is a contract. So item number 2 on our list is you can transfer things by a contract. So a revocable living trust is a contract. It's a contract between the settlor, the creator of the trust, with another person to hold money and pass it to one or more beneficiaries after death. So that's how a trust works. A trust works by effectively creating a contractual relationship to avoid probate court. And most of our work here at my office is to avoid courts on behalf of people. We want to avoid judges. Judges in California are very nice, they're very friendly, they want to do the right thing, but they are limited by the rules and requirements and procedures of the courts. And the courts in California take a long, long time, and they're very expensive and they're burdensome. The trust is much more easy to operate. So if you have more than $184,000 of liquid assets, more than $50,000 of real estate, it's really a good idea to talk to a certified estate planner about creating a trust. My name is Elijah Keys. My firm is in Milpitas, California. We do trusts all the time. We're happy to help. Thank you very much for joining us today as we talked about the 4 ways to transfer assets after death. Please like and subscribe if you like our content. Let us know in the comments what other topics you'd like us to cover. Thank you very much for joining us.